Brendan Dassey Trial Transcript Day 7, continuing on page 103, redirect examination of Michael Riddle by Attorney Freeman. Do you know whether or not Brendan Dassey has characteristics of his hands that are dry or greasy? I would have to examine his hands. I couldn't tell you that. You can certainly say, however, that as to the 3 items in the vehicle, they did not match the known sample of the fingerprint of Brendan Dassey? No, they did not. Now, you mentioned that often smoother surfaces are easier to either find a visible or even a latent print. Yes, they are. Would smooth steel handcuffs be something that might be able to extract a fingerprint from? They could possibly. Again, I'd have to examine the handcuffs to be able to tell you if that sort surface would be good enough or if they were in good shape. There's a pretty good chance I could find them. But I've seen some of these cuffs that the finish was worn off and they were rusted. And in a situation like that, it'd be more difficult. Would these, for instance, be something that you might be able to extract a fingerprint from? I believe so, yes. And I'm showing you what's been marked as Exhibit 92. It's actually crime lab number CJ-2. Okay. But you weren't provided with these. No. To review, this is the first time I've seen them. Thank you, Attorney Freeman. Nothing else. Recross examination by Attorney Gahn. And again, items can be cleaned or wiped off, fingerprints wiped off or cleaned from an item. That's correct. Thank you, Attorney Gahn. That's all I have. Also, the court. You may step down. Mr. Freeman, any additional witnesses this afternoon? Attorney Freeman, we'll have a psychologist who's prepared to testify starting at 8:30 in the morning. Take a probably majority of tomorrow. The court, all right. I take it that's no for this afternoon? Attorney Freeman, sorry, no for this afternoon, correct. The court, all right. Ladies and gentlemen, I'm going to excuse you at this time. Remember, you are not to talk about the case or anything you've heard or anything connected with it. Thank you. Jury out at 2:14 p.m. The court. Counsel, before coming out here on the record, we had a brief discussion in chambers. It's my understanding there's some matters we should make of record this afternoon. Mr. Kratz, I'm going to turn to you first. You may or may not have a motion or an argument. Attorney Kratz, I do, Judge. If I could have just a moment to grab my materials. Thank you, Judge. As this court recalls, a motion was argued in a pretrial manner regarding the admissibility of testimony of a Dr. Robert Gordon. Dr. Gordon provided this court thorough videotape testimony with something called an offer of proof, which is expected trial testimony, and based on an opinion on what Dr. Gordon believed evidence at this trial was going to establish. Dr. Gordon, as this court knows, has opined in a written report and in his offer of proof that Brendan Dassey was, in fact, an individual who was, using his term now, vulnerable to suggestibility. The state had objected in a oral argument, as well as a written provisions to the court, to Dr. Gordon's testimony, noting that this kind of evidence has not been admitted in the state of Wisconsin, at least to this point. And whatever marginal relevance there may be is certainly outweighed by the danger of confusion of the jury or unfair prejudice. Nonetheless, the court reasoned in a pretrial decision that Dr. Gordon would be allowed to testify as to the area of suggestibility, again, based upon an offer of proof. I recall, and I'm sure the court has a recollection as to my argument, both oral and written, cautioning this court as to its pretrial ruling prior to even knowing what the trial testimony was going to be, especially as it relates to foundation or to relevance. And what I argued, Judge, was that it's going to depend on who is going to testify in this trial that Brendan Dassey's statements were the product of suggestibility. In other words, that somebody had to come before this court and claim that Brendan Dassey's statements to law enforcement officials were in fact the product of law enforcement behavior, law enforcement suggestibility, or at the very least some coercive practices by law enforcement for Dr. Gordon's testimony to ever be relevant. Relevance, of course, is well defined, and this court included that in its pretrial ruling. And I'm not going to re-argue or belabor that. I agree with the court's definition and explanation as to relevance. Now, however, we're at the point in the trial where we don't have to guess as to what the trial testimony is going to be. We don't have to call it an offer of proof anymore, or expect or presuppose what some trial testimony may be. We've now heard what the defense theory of the case is, what the defense version is, and as announced by this court and as predicted by the state in my written brief, Brendan Dassey himself has testified and has provided to the court with a version of events or an explanation as to the admissions, or what we referred to as the confession given in this case. Importantly, Judge, Mr. Dassey today, when testifying in this trial, said nothing of suggestibility, despite Mr. Freeman's best efforts in continuing to ask Mr. Dassey about things like suggestibility. Mr. Dassey's responses, when he didn't say, "I don't know," Mr. Dassey's response was something called confabulation. That is, that he made it up, that he made up the version of events that he told law enforcement officials. Confabulation is, of course, absolutely a separate concept than suggestibility. And when Mr. Dassey and the defense, through Mr. Freeman and Mr. Edelstein, who I assume knew what Mr. Dassey was going to testify about today, present that theory of defense, and that theory is devoid of any mention of suggestibility, well, then Dr. Gordon's testimony just simply no longer becomes relevant. This court's pretrial order and ruling, which the state respects very much, must simply is no longer based upon what the trial evidence is in this case. When Mr. Dassey explains that the version of events given to law enforcement is the product of fabrication, or even if we believe that it's the product of some memory several years ago of some book that he may or may not have read, it is just not suggestibility. I then, and at this time, renew my motion, ask the court to reconsider its finding as to Dr. Gordon's testimony. We're asking that Dr. Gordon's testimony be excluded. We don't believe there is any foundation in this record, nor is there any relevance to Dr. Gordon's ultimate opinion that Mr. Dassey is vulnerable to suggestibility. Now, we understand that this court has already limited Dr. Gordon's testimony. This court's already previously indicated that Dr. Gordon can't talk about whether the confession was true or false, that is, whether it was a false confession, can't talk about a coercion or the circumstances surrounding the interrogation. And although there are experts that can talk about that, Dr. Gordon admits that he's not one of those kind of individuals. But his testing and his opinion, as limited to suggestibility, simply is not relevant. Would ask the court revisit and exclude the testimony. Alternatively, Judge, we are asking if the court continues to allow Dr. Gordon's testimony in this case, despite the lack of foundation for his testimony, we would ask the court reassert or restate just what it is that Dr. Gordon can testify about, just what is relevant about Dr. Gordon's testimony based upon the record currently before this court. We certainly don't want to be in a position where we're needlessly objecting during direct examination, or that the state unnecessarily has to cross-examine Dr. Gordon on issues that may, in fact, not be allowed through this court's orders. Lastly, Judge, at the conclusion of this motion, that is, at the conclusion of my motion to exclude or the renewal of my motion to exclude, I would ask also to place on the record the state's request to call, if necessary, rebuttal witnesses. But I have, unfortunately, gotten ahead of myself, and I'm just alerting the court that we do have that issue to discuss as well. That's all the comments I have regarding Dr. Gordon's issue. Thank you, Judge. The court. Response? Attorney Freeman. Just a brief one. Well, I'll try to be brief. The state began its argument by indicating that they expected Dr. Gordon to testify as to what evidence would indicate in this trial. Well, I don't think that's ever been what we've offered to this court, and I'm certain that's not what the order of this court is. What we've offered previously is that the doctor would testify as to his conclusions based upon his evaluation of Brendan, his review of the collateral information, which included the videotape statement that was shown in this court, as well as other statements that had not been provided to the jury, and he would also testify as to the different tools of evaluation the different tests that he actually conducted and the purpose for those tests, including the Kajunson suggestibility test. We intend to offer the same testimony with the same limitations that the court imposed on his testimony per the order of April 5. The state's argument today is that there needs to be additional foundation, essentially, or that there hasn't been a sufficient foundation placed on the record for the doctor's testimony. Part of what the state argues is, well, I think maybe he misspoke, but Mr. Kratz said foundation as to suggestion or coercion. We've never once indicated that Dr. Gordon would ever testify as to any coercion. In fact, he even, in the offer of proof, said, I don't have the ability to do that and would not offer his opinion as to the officer's techniques in regards to coercion. So that was never an option. It was never going to be something offered to the court. The indication that we provided to the court with the limitations in the order, simply that he would be testifying about the issue of suggestibility or vulnerable to suggestion, as I think he referenced in his report. So far, the testimony on direct and on cross of the defendant was that, as to many questions he answered, I don't know why. When asked why he would admit to a serious offense, such as sexual assault or first-degree intentional homicide, his answer is, I don't know why. I probably could count up on the transcript and come up with at least 20 or 25 times that came out. There were times in final cross by Mr. Fallon that this idea of confabulation came up, but there's equal or more testimony in regards to why he did what he did, and his answers were, I don't know why. Our intention is to wrap up what we've started with, all the witnesses, with the Officer Wiegert and with Detective O'Neill for that matter. Attorney Edelstein questioning of at least with Detective Wiegert, was essentially 90% suggestibility issues, promises, lies, suggestion, and leading. With Detective O'Neill, there was a number of questions about suggestion, leading, promises. In fact, the state brought up the subject when the state says there's devoid of anything in the record about suggestibility. The state, on cross of the school counselor, asked her about suggestibility. So the issue has been raised by the state as well. We would certainly object to the ruling changing the original ruling. And as far as offering to the state some sort of a roadmap of where I intend to go, or some formalized transcript of the question and answers that I intend to elicit from the doctor, I guess I would offer again, we will follow what the court ordered, the offer of proof with the limitations that this court has set up the testimony. And as to providing to the state some sort of heads up, as so to speak, I guess I would just mimic what the state has told me throughout this trial. I'll question my witnesses how I want, without having to answer to the state. And so I would follow the order that the court placed on us, and I don't believe that there has been this lack of foundation that the state is suggesting with the court now to change the ruling before in regards to Dr. Gordon. The court, Mr. Kratz, any response? Attorney Kratz, I don't have any. Thank you, Judge. The court, all right. Both parties have noted the court has had an opportunity prior to this day to take up the issue of Dr. Gordon and any testimony that he might have to offer. The court ruled that Dr. Gordon's testimony, and I did this based on a couple of things, or based on the instance of seeing a proposed offer of proof from the defense by way of DVD, and as well the testimony educed by Mr. Kratz at a cross-examination of Dr. Gordon. Under Section 90702 of the Wisconsin statutes, expert witness testimony is permitted if the proffered testimony is relevant, if it will assist the trier of fact in some way, shape, or form, if the expert is qualified, and if the testimony that's going to be offered is not superfluous or a waste of time. This all stems from a case called State versus Walstead at 119 WIS 2D 483. I found initially that all of these qualifications were met. There also is a secondary line of reasoning that can occasionally be employed, namely that by virtue of the Sixth Amendment of the U.S. Constitution and Article 1, Section 7 of the Wisconsin Constitution, a defendant should have the right to present a defense. And while I didn't make a finding directly on that point, I think I alluded to it, at least collaterally, in arriving at the ruling. Mr. Kratz says, in effect, that based on the testimony offered by this defendant in person today, that foundation for any kind of testimony from Dr. Gordon with respect to suggestibility is, in effect, vitiated, that is to say, taken away. That his testimony, Dr. Gordon's testimony, no longer becomes relevant.